Hi everybody, Dave Sugden. Today we are going to talk about the psychotherapist-patient privilege. And when we talk about privileges, we are talking about this area in evidence that we describe as exclusions and limitations. And so when we think about evidence questions, we always start with relevance. Is this piece of testimony, is this document, is it relevant to our case? We then talk about issues of foundation, then we get to hearsay. And when we are talking about exclusions and limitations, we are talking about evidence that is relevant, but for some reason, the law has said for policy reasons, we're going to either exclude or limit the evidence. And among these limitations is the psychotherapist-patient privilege. And so when we think about privileges, these are, for example, attorney-client, physician-patient. And the one we're going to talk about today is the psychotherapist-patient privilege. And what that says in essence is a confidential communication between a patient and psychotherapist is privileged unless there's a waiver or an exception to the rule. And today we're going to talk about waiver, and we're going to talk about it in a recent case by the Court of Appeal. But to understand waiver, we look at Evidence Code Section 912. And what Section 912 is essentially the waiver rule to any privilege. The psychotherapist privilege is found in Section 1014 of the Evidence Code. And whether we're talking about the attorney-client privilege or a physician-patient or psychotherapist-patient privilege, we go to Section 912, and it describes when a waiver takes place. And it says, in essence, that the holder of the privilege without coercion, so this is someone who voluntarily discloses or consents to the disclosure, a significant part of the communication. So what does that mean? To understand that, we're going to look at Fish versus Superior Court. In that case, there was a car accident. And at the scene of the crime, the scene of the alleged crime, Mr. Fish speaks with law enforcement officers. People were killed at the accident. And at the scene of the accident, police talk to Mr. Fish, and he says, among other things, I'm being treated by a psychotherapist, and this psychotherapist has prescribed me certain medications. He's then charged with vehicular manslaughter, and during the workup for the trial, a subpoena is sent to his psychotherapist to get all the records and to talk to this psychotherapist. And Mr. Fish's team say, nope, this should not be allowed because this is protected under the psychotherapist-patient privilege. And what the DA argued is, no, this has been waived because when he, at the scene of the accident, tells the police officers that he's seeing a psychotherapist, that he's being prescribed medication, he has therefore waived this privilege, and we should now be entitled to discover additional information. And what the court looked at is whether or not that had been a waiver, and specifically it looked at the language of 912 to decide whether or not when Mr. Fish spoke with law enforcement officers and disclosed this information, was that a significant part? And the court explains the policy behind these privileges, in particular the valued protection for the psychotherapist privilege, and explains, look, we're going to interpret this privilege broadly and interpret exceptions or waivers narrowly. And then that being said, it basically talked about there being tiers of disclosure, and until you get to the significant part disclosure, the privilege is still intact. And so what the court said is, look, merely disclosing the existence of the relationship isn't enough. And so when Mr. Fish says, I'm being treated by a psychotherapist, that is just identifying the existence of the relationship. That's not a waiver. And we see that in the attorney-client privilege, for example. Simply saying, I have an attorney, talks about the existence of the relationship. It's not a waiver. In addition, Mr. Fish talked about the purpose of the relationship, where he said why he's being treated by this psychotherapist and identified the medications he was taking. And the court said, look, that is simply describing the purpose of the relationship or the purpose of the confidential communications. And so, again, looking at the attorney-client privilege as an analogy, talking about the reason someone got a lawyer is talking about the purpose of the relationship, not a waiver. And so the court said, no, Mr. Fish still has his privilege intact because he simply identified the existence and the purpose of these confidential communications. Just talking about the medications he was provided is not a significant part. The court does say that when it comes to identifying what is a significant part, that is part of judicial interpretation. And so this analysis will invariably be very fact intensive, but what the Fish Court does is provide a good framework for identifying when the waiver can take place under Section 912. And so that's the Fish versus Superior Court case. I would encourage you to check out evidenceattrial.com. We have live events, we have online courses where we do a deep dive on questions regarding the rules of evidence and how we can apply them effectively at trial. Thanks for watching.